Hello, everyone, and welcome to Uncivil Law. I hope you, as always, are having the most wonderful of days. And we are here with yet another edition of Supreme Court React. Today, we will be reacting to the case of Allen v. Cooper. This deals with copyright issues and state liability for infringement of copyright. Can you sue the government if they violate your copyright? That is the issue at hand. I'm going to read a description of the case from the facts of the case. This is, as always, from OEA, from their description of the case. So let's get started. Facts of this case. In 1996, a private researcher hired petitioner Frederick Allen and his company, Nautilus Productions, to document the recently discovered shipwreck of Blackbeard's Queen Anne's Revenge, which ran afoul at Beaufort, North Carolina in 1718. Allen documented the shipwreck for nearly 20 years in photographs and videos and registered his work with the Copyright Office. At some point before October 2013, the state of North Carolina posted online various of the copyrighted works of Allen's without his permission. In 2013, and later that same month, the state and other involved parties entered into a settlement agreement with Allen and his company, paying him for the infringement of his works and agreeing not to infringe the work going forward. So they infringed his rights, purportedly, in October 2013, and sometime later that month, entered into a settlement agreement and pledging not to do it again. At the same time, the state removed its infringing works, but shortly thereafter again posted and published the works. The state then published Blackbeard's Law, that's really what they called it, which purportedly converted Allen's work into public record materials that the state could use freely. So you see what happened here. Allen filmed this shipwreck for 20 years, registered his work. The state infringed it, posted it online without permission. Allen reached a settlement with them. They pledged not to do it again. And then North Carolina said, no, actually, we've changed our mind. What we're going to do is we're going to post it again, and we're going to pass a law specifically saying that we can do this. Okay. Allen then sued for copyright infringement, as you might imagine. This is where it gets complicated. Because if it were just like a normal individual, copyright infringement, breach of contract, breach of license, these would be your normal theories, right? Leonard discusses this all the time. In fact, he just had a live stream where he was discussing this. So if we're a non-state actor, breach of contract, breach of license, copyright infringement, tortious interference, these are your like go-to causes of action, right? Well, this is where it gets complicated. The state of North Carolina moved to dismiss on the grounds of sovereign immunity under the 11th Amendment of the U.S. Constitution. We'll read that in a second. Allen argued that the Copyright Remedy Clarification Act, which is a federal statute, which defines potential infringers of copyright to include, quote, any state, any instrumentality of a state, and any officer of a state or instrumentality of a state acting in his or her official capacity, unquote, abrogates state sovereign immunity for copyright infringement cases. So Allen is saying there's a federal law that specifically says we can sue the state. The district court denied the motion to dismiss, finding persuasive Allen's arguments regarding the federal statute's abrogation of sovereign immunity. The Fourth Circuit reversed, finding Congress lacked the authority to abrogate state sovereign immunity via the Copyright Remedies Clarification Act. So the Court of Appeals said, yeah, Congress did it, but Congress can't do it. They lack the power. They lack the power to give a remedy that allows you to sue them in federal court. Thus, the question presented in our case: did Congress validly abrogate state sovereign immunity via the Copyright Remedy Clarification Act, which allows authors of original expression to sue states who infringe their federal copyrights? With that out of the way, let's read the 11th Amendment of the Constitution so you can understand a little bit more about what it says. It is not the most easily explained. It is one of the more obscure provisions, but we will read it together and see what. I will change the spelling of it, so no, thank you very much. I misspelled it, as I sometimes do. Thank you. It's not supposed to be Scouts. It's supposed to be SCOTUS. Yay. Let's change that. Better. Thank you. So no. The 11th Amendment to the Constitution of the United States says, is the Circuit Court argument a 10th Amendment argument? No, we are in the 11th Amendment. We're in an 11th Amendment argument. The 11th Amendment says, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by a citizen of another state or by citizens or subject of any foreign state. So basically the 11th Amendment says that the judicial power of the United States does not extend if a citizen of another state wants to sue a state in federal court. So that's the issue. Whether or not this applies or not in this circumstance. And what is very interesting is that this may be the only amendment, potentially, depending on your point of view. You can make a case for others, but it's probably the only amendment which is a direct response to a particular case. You've often heard that the only way to overrule a Supreme Court's judgment on the Constitution is by passing a constitutional amendment. Well, that's exactly what happened. There was a case called Chisholm versus Georgia, which said federal courts could hear these cases, and they passed a constitutional amendment specifically to undo that decision. So it was a decision specifically to undo that decision. And of course, as I was indicating, you can make that claim for the 13th Amendment, 14th Amendment as well, dealing with the cases that came before that. Dred Scott, for example, you could argue it was done to undo that case, but I don't know if you call it a direct reaction as much as a consequence of the Civil War. But anyways, that is the 11th Amendment. All right. We are now going to listen to the oral argument in this case, and we're going to all learn a lot because the 11th Amendment doesn't come up a lot, as you might expect. And we're going to see, what applies. So it should be very, very interesting, very, very educational for everyone. So let's get started with this. Of course, Mr. Allen, the copyright holder, is the losing party. He's the one appealing. His copyright has been rendered invalid, or at least not applicable, as it applies to North Carolina. And so we're going to hear from Mr. Allen's argument that his copyright should apply. Let's get started.
We'll hear argument next in case 18-877, Allen versus Cooper. Mr. Schaefer.
Mr. Chief Justice, and may it please the Court. When states infringe the exclusive federal rights that Congress is charged with securing, Congress can make states pay for doing so.
Oh, sorry, that's my fault.
Our respectful submission today, one that follows from the Constitution's text and affords ample basis for this Court to uphold the work Congress did in enacting the CRCA. Article 1, Section 8, Clause 8, what we're calling the Intellectual Property Clause, is unique within Article 1 in laying down an express constitutional mandate for Congress to protect specified private property rights against any and all intrusion. Consider just how pointed and clear the constitutional text is. Congress is not only to be granting copyrights, but securing them. And the resulting rights, by definition, are meant to be exclusive rights. Exclusive against whom, Your Honors? Exclusive against all comers. Exclusive against the world, including the government and including states. And this exercise of congressional power serves the express constitutional purpose to promote progress. How? By affording monetary recompense to copyright holders. The framers thus made very clear that all those wanting to use an author's copyright are meant to be paying money for doing so. This clause's text signals a plan of the convention waiver like no other in Article 1. For states to retain immunity to avoid paying for infringing the very same exclusive rights that Congress is meant to secure would be incompatible with the text as fixed and understood by the framers. And this Court has already so recognized in substance, going back to 1888 in United States v. Palmer, The court said in holding the federal government monetarily liable for infringing patents that Congress's power, the same power we were just talking about, could not be affected if the government had a reserved right to infringe. Same reasoning holds for states, Your Honors. And in Goldstein v. California in 1973, the court said, and again here discussing copyrights, when Congress grants an exclusive right or monopoly, its effects are pervasive. No citizen or state may escape its reach.
All that would be highly persuasive if we didn't have the patent decision, the Florida prepaid decision. It is the very same clause. It's the very same secure. It's the very same exclusive.
As Justice Ginsburg is alluding to here, there is some case law on point. As you might imagine, this is not the only time an issue like this has come up. And the Seminole Tribe is the big case on point, basically says that Article I powers cannot be generally used to circumvent sovereign immunity in order to overcome the 11th Amendment. And she's referring to Florida Prepaid, which was a case dealing with patent law, which was exactly the exact same clause, which was being analyzed and found a lack of jurisdiction. So he has to distinguish the patent case, Florida Prepaid, and he has to distinguish the Article I master case, you might call it, Seminole Tribe. So let's see what he has to say in terms of distinguishing.
Correct, Justice Ginsburg, but the court was not examining the text. The court was not examining the clause. In fact, it didn't even grant review on the question whether the Article I basis for the Patent Remedy Act would be a valid basis. That wasn't before the court. It wasn't even raised before the court. And so all the court did, Justice Ginsburg, was refer back to Seminole Tribe, the sweeping assumption.
So that's what I was talking about, the big Article I master case that basically says Article I powers in general are not a sufficient basis to overcome sovereign immunity. So he's saying, look, in the patent case, they didn't really analyze the clause unto itself. All they did is look back at this master clause. So they didn't make a particularized rationale in the Florida prepaid case. So if you want to make a particularized rationale, that is not foreclosed by Florida prepaid. You know, the general case is Seminole Tribe. If you want to make an exception for the specific case, you know, Florida prepaid would be the best case on point, but it doesn't exclude it because all it did was refer back to the general case. So that's why he's trying to say, look, this Florida prepaid case really isn't precedent that applies to me. It's not really, doesn't have any force or effect because it didn't try to analyze it as to its specialness, and I want to make it special. So let's listen on.
Of Seminole Tribe that no Article I clause could ever supply basis for abrogation. That's the same assumption that the court in Katz more recently called dicta and held to be erroneous dicta, an erroneous assumption, which is the only way that the court was able to analyze the specifics of the bankruptcy clause and find that it did reflect a plan of the convention waiver and a basis for abrogation.
In Katz, the court concentrated on the bankruptcy authority as a unique authority. We have Seminole, which is across the board, and then we have the exception for the bankruptcy clause. Now, are you asking us to go through all of the Article III authority and take them one by one?
So here, Justice Ginsburg is referring to the fact that the bankruptcy clause, which gives the federal courts exclusive jurisdiction for bankruptcy, that Article 11 has already been read not to apply to that. So there's already at least one exception, potentially, to the general rule of Seminole Tribe. There's this the tribe of and then the bankruptcy clause. So she's saying, well, what do you want us to do now? Do you want us to go through these provisions one by one and decide whether or not they make exceptions? Like, basically, it would be the equivalent of incorporation doctrine when it comes to the Bill of Rights. So basically, we're going to go through, incorporation doctrine, we went through each of the Bill of Rights and decide whether or not they applied. So now you want us to do the same thing again, as it applies to this. You want us to go through and determine for each one of the powers in Article 1 whether or not it does or does not have an exception in this rule. It's like, you want us to do this piecemeal thing? So that's what she's asking there. Very good question, looking to the future. So let's listen on.
Isn't Katz more properly read as a bankruptcy exception to the Seminole Tribe rule?
Your Honor, we rely upon the methodology of Katz, and we rely upon the upfront holding of Katz. We take it to be a holding that, in fact, what Seminole Tribe had said about no Article I power supplying a basis for abrogation, that was dicta and that was an erroneous assumption. In fact, the relevant portion of Seminole Tribe, as both the majority and the dissent in that case recognized, it dealt with the copyright clause and the bankruptcy clause and the commerce power all in the same breath. It was the same.
And because I read the erroneous dicta language, maybe I'm misreading it, so you can tell me how, as just a reference to the statements in Seminole Tribe about the bankruptcy clause.
It's the same sentences, Justice Kagan. It's the same exact portion of Seminole Tribe that dealt with all Article I clauses in the same breath. And in fact, in Justice Stevens' dissent, and I think it was the first footnote of it, he noted that the Seminole Tribe decision by its terms would apply to the would apply to the copyright clause and to the bankruptcy clause. And Justice Rehnquist, I think, in Chief Justice Rehnquist in footnote 16, I think, engaged that assumption and said, yes, essentially, no big deal, but that is the necessary upshot of the Seminole Tribe holding as it was articulated by the Court. And that's why I think in Katz, this Court had to deal right up front with whether that assumption held or not, and it rejected it as erroneous. But Justice Ginsburg, Justice Kagan, let me assure the Court, there is no other clause in Article I like this one. There is no other clause that is as pointed. There is no other clause that contemplates that there will be private property rights.
I think he can distinguish that. I think he can try to distinguish along the lines he's trying to distinguish that Article I talks about granting private rights by its own explicit terms, right? Congress may grant to authors and inventors the rights for their respective discoveries, right? So he's saying it's unique in that it's contemplating private property, and it would be odd for a government to be able to just take that private property without any sort of liability. So he's trying to distinguish it on the clause's text and say, well, every other clause is different. Now, on one level, I tend to agree with him. It is different. But on another level, I'm still worried about the next guy who's going to come along and say, well, actually, this other clause of Article I is also special, not because it provides a private property right, but insert reason here. Try to distinguish it. And it just becomes an exercise of everything being distinguished from everything else. So on one level, I'm like, yeah, you can distinguish. But on the other level, I'm like, can you distinguish everything from everything? And then we no longer have a rule. And if so, is the rule stupid? And if so, then what's left of the 11th Amendment? Because if Congress can abrogate sovereign immunity with Article I powers, then what in the heck is the 11th Amendment trying to do? I mean, presumably the 11th Amendment is modifying Article I, at least in part. So if you say, well, any Article I power undoes the 11th Amendment, then you've just written out a constitutional amendment. So he has many problems. Evil Tribble, he has a compelling pragmatic argument, but the legal argument I think is a lot more tricky. But let's listen on.
If you were right, we would then have to go back to Florida prepaid, right, and topple that rule.
No, it would be certainly open to folks in patent cases to make that argument, Justice Kagan.
How could we have the two rules going simultaneously?
That would be my prediction. My prediction is that ultimately the Patent Remedy Act would be revisited and properly upheld as a valid exercise of Congress's Article I power.
So basically you're asking us to overrule Florida prepaid.
I'm asking this Court to follow Katz, Justice Alito, where I think Florida prepaid was overruled in relevant part. And certainly —
You think Katz overruled Florida prepaid?
I think it overruled the basis for Florida prepaid. The precedential foundation for Florida prepaid was solely the relevant portion of Seminole Tribe. That's exactly what the Court was I think, calling erroneous dicta and rejecting. So I take the holding of Katz to have totally undermined the foundation.
So you think
Florida
the state
prepaid.
of the law is that every Article I, Section 8 power would have to be considered independently, and Florida prepaid may hold on for a while as a poorly reasoned exception to that rule, but ultimately would have to be overruled to bring it in line with the position you're asking us to adopt today?
I have only one friendly amendment to Your Honor's assumption. which is I don't think that there is any other Article I clause that reflects a plan of the convention waiver in the sense that we're discussing, in terms of the constitutional and text and the necessary implications of it. Because for the reasons that this Court has already recognized, we think it is totally incompatible with the framers' text and the framers' contemplation to say that there's any such thing as an exclusive private property right secured by the United States Congress that states are free to infringe without paying. I think that would have been antithetical to the framers' conception. That's our respectful submission on Article I. And if the Court doesn't have other questions about that, I'll move on to
do you think Florida prepaid is subject to our usual stare decisis rules or not?
Well, Justice Kavanaugh, obviously the Court will decide what is its precedent. We read Florida prepaid as not having really squarely addressed this question. I don't think Florida prepaid reached a holding on the Article I point because the question was not before the Court there.
Well, the Court said the Patent Remedy Act cannot be sustained under either the Commerce Clause or the Patent Clause. Before that, it said Seminole Tribe makes clear that Congress may not abrogate state sovereign immunity pursuant to its Article I powers.
It said that without the question having been presented and without any party arguing the question, which is why I would respectfully question whether it's truly a holding, Justice Kavanaugh. But if it was a holding, it was, just as Your Honor articulated it, based solely on Seminole Tribe, the very same aspect of Seminole Tribe that we read the Court as revisiting and overruling in Katz. But the Court will decide the status of its precedent. If it has any qualms about the Article I basis for the CRCA, I would ask the Court to sustain the CRCA on the strength of the section.
Altira Mongras says, what about the Takings Clause? Very good question. Yeah, the Fifth Amendment to the Constitution, right? So, like its original text, the Fifth Amendment to the Constitution applies against the federal government. So the 11th Amendment, which talks about state liabilities, wouldn't read on that. So then the question becomes the Fifth Amendment as it applies to 11th Amendment questions. And traditionally, at least, the Fifth Amendment Takings Clause, and there may be exceptions to this, and if there are, I can't remember any off the top of my head, but the Fifth Amendment's Takings Clause has only been held to be a issue that applies to real property, that is land, and the accoutrement of land. So it's applied to things like people wanting to dig to put in cable lines or, regulatory takings of land, physical buildings and things like that. And until 3 years ago, there was a case that changed this, but it basically said you had to go to state court, and I think you still have to go to state court first. But I think you can ultimately appeal to the federal courts on the basis that it's not in compliance with the federal Constitution. It's been a while since I read that case. So you may still have to I think you do have to start in federal court, but you can ultimately appeal to the federal court. And that's a little bit different because you're not, strictly speaking, suing the federal government, or you're not strictly speaking suing the state government in federal court. You're appealing to federal court rather than you're suing them in state court, and you're saying it's a constitutional violation. So that gets you past the 11th Amendment question. The problem when it comes to the copyright clause or patent clause is there's no state cause of action. Takings remedies exist in every state to varying degrees when you can sue for land. Because it happens quite frequently. No state has remedies when it comes to copyright and patent, not for the least of reasons is because the federal government has preempted the field. They have taken over the field. So especially in patent law, there's no such thing as state patent law. It doesn't exist. There's a little bit of state copyright law still hanging around in music, especially, but not much. They've preempted the field. So it would be very hard to sue in state court in the first instance because there's no state cause of action because there's really no such thing as state rights. There are only federal rights, and you can't sue for federal rights in state court, and you can't sue them in federal court because you have no cause of action because of the 11th Amendment. So it's basically a huge circular loop, right? It's I can sue, but I can't because this, and the sue, because I can't. So yeah, you wind up in this situation where you might be wronged, but you have no remedy, which would be very unfortunate if that's true. But yeah, I think the Takings Clause cases can be distinguished because, as far as I know, all the Takings Clause cases have been on real property, and they always start in state court. So they're a little different there. I don't know if there's been a Fifth Amendment taking case on private, personal property or not. Probably, but I can't think of one off the top of my head. But let's listen on.
5 of the 14th Amendment base.
Can you articulate what plan of the convention means to you? Know what it means in Katz, and they look to a textual foothold, the ability of habeas courts to grant relief to state prisoners. So that's a clear intrusion on states. I don't see the same thing in the intellectual property provision. In fact, for 200 years, there was concurrent state and federal jurisdiction. That seems to cut against your argument that somehow the founders thought that this was an exclusive federal right.
And that's fair enough. Copyright, especially as I was pointing out and alluding to, had much more state interest or much more state copyright. Was there ever state patent? I don't know, but there might have been remedies in state court. But yeah, at least in patent law, they changed that in 1952. I would imagine they changed the copyright around the same time, so it became more exclusively federal. So like the idea of, you know, the Congress making exclusive and taking away your remedy in state court is something they can do, but whether or not you can sue the state in federal court is a whole other set of problems.
Take those in turn, Justice Sotomayor.
Or exclusively, an exclusive right to the federal government.
A plan of the convention waiver refers to some reflection that states were surrendering their backdrop default sovereign immunity in a discrete respect as part of the constitutional
You don't
convention
think
that came out
that
of it.
exclusive jurisdiction would have signaled that more clearly than concurrent jurisdiction for over 200 years?
I think that our textual basis for the abrogation is stronger than it was in Katz. In Katz, as you say, Your Honor, I don't think it was in the bankruptcy clause, the plan of the convention waiver. And as to habeas jurisdiction, that was not about monetary relief against states. That was not about hauling states into federal court. It was just about granting relief, habeas relief, to get prisoners out of state prison. I don't think that that's anywhere near as on point as what you have with the intellectual property clause, where clearly the framers' contemplation is these are exclusive rights that anyone who may infringe has to pay for. Congress's job is to secure those rights. It cannot do that without abrogating state sovereign immunity within this discrete realm.
The latter part you're assuming. Nothing about it. It says securing the copyright, but it doesn't say making sure that the copyright owners are paid.
To promote progress, Justice Sotomayor, it is a preamble that is not echoed anywhere else in Article 1.
Some would say that injunctive relief promotes progress.
Well, James Madison.
That's a damages question. That's not an issue of what promotes the arts.
James Madison's conception reflected in the text of what the monopoly would achieve is that the authors and inventors would get paid for their inventions. They would get paid for their creations. And as the Court, as I indicated, back in 1888 recognized, it is antithetical to that to say that government of any kind, certainly the federal government, can infringe those exclusive rights that Congress is to be securing. But as to Section 5 of the 14th Amendment, Your Honor, this is a case and a legislative record different from what the Court had before it in Florida prepaid. It is much stronger in relevant part. In part, that's because of the fundamental difference between copyright law at issue in this case and patent law that the Court was looking at in Florida prepaid. In part, it's also because you have a legislative record that is so much stronger, Your Honors. You had the Register of Copyrights, Ralph Oman, testifying to Congress, preparing a report based on a 50-state survey and a very conscientious compilation of comments and studies about what was happening to federal copyrights and why this legislation was necessary to protect them.
But you tell us in your brief that when Congress enacted the CRCA, it had, quote, 16 examples over the previous decade of reported state infringement in 13 states. Is that enough to identify a serious constitutional problem?
I think so, Justice Alito. I think, first of all, as to the serious constitutional problem, you have federal property rights that have been granted and that are private property rights, and states are infringing without paying for it. That is a fundamental intrusion. That is a fundamental constitutional problem. And I think Congress, if it has a remedy that is conscientiously tailored around that, should have, as the Court put it in City of Bernie.
16 examples is not enough. And the mere fact that there were state infringements.
I'm not quite sure what they're talking about here when they're talking about 16 examples are not enough. It almost seems like they're saying, and I loathe to put these words in their mouth because I'd have a hard time believing it. But it almost sounds like they're saying that, 16 times that various states have violated these people's rights isn't that big a deal because it's only 16 times. But, if they're rights that belong to people, then one should be enough, right? The infringement against one is a problem. Like, if the government comes after you and says, we're going to prevent you from speaking, I don't know how much of an argument it is for the government to say, but it's only one guy. We passed a law specifically dealing with this one guy and only him, so it doesn't matter. I don't know that works. So if the argument is, but they've only done it 16 times, therefore it's not that big a deal, if that's what they're getting at, I'm like, it kind of is a big deal. I mean, one is a big deal. Now, Sotomayor, I think, or Kagan, maybe it was talking about remedies issues. And yeah, there's a remedies issue. Like, what is the remedy for that? Maybe there's, that's a whole other set of questions. But like, to say 16 isn't enough, but some other number would be, I don't buy that. Let's carry on. Jake the Hammer says maybe they mean the plural of anecdote is not data. Yeah, maybe they mean something more like that, because I'm like, my interpretation, the first interpretation that comes to mind when I read it is like, well, that can't possibly be what they meant. But yeah, your interpretation is also plausible and probably like more reasonable. So it's like, yeah, we don't know what the deal is because it's only happened 16 times. So we don't really know what we're talking about. That's a much more valid argument, right? If it's like, we don't know really what we're talking about because it's only happened 16 times, and so we don't have enough to really understand the parameters of this thing, that's more of a practical problem than a like threshold problem. It's like, I haven't seen enough examples to build a model. And like, okay, that makes a lot more sense. So yeah, let's hope that that's what they mean. I'm having trouble building a model rather than it doesn't matter. Let's carry on.
Doesn't necessarily mean that there were state violations of a constitutional right, does it?
We think it follows in the copyright context, Justice Alito.
Every infringement is every infringement by a state or by the federal government is a constitutional violation?
The nature of the exclusive intellectual property right is that one will have the right respected or else be compensated for an intrusion. That is the nature of intellectual property. And for copyright in particular, Justice Alito, infringement by definition means someone has copied the protected original expression of the copyright holder. And yes, we think that that is a constitutional violation pretty much every time.
What if it's negligent?
I don't think Justice Alito, I don't think it can be negligent in the relevant sense. The government may commit procedural due process violations by doing all sorts of things negligently, denying notice, denying opportunity to be heard, of spurious welfare cancellation. Those things offend procedural due process. But there's also a takings basis for this legislation. And the Court has been very clear that a taking can occur even through a regulatory taking, as in Penn Central. And so if there is a predictable result of a government action that denies someone their protected property rights and does that without compensation, that is a 14th Amendment problem. I submit that that's true in every case, but it's certainly true in most cases. And the Court's been very clear that Congress has prophylactic and deterrent rights under its Section 5 power. And I would also note, as to the 16 examples that we're talking about, those examples are really in the nature of reports, Justice Alito. So one of those reports was from the Motion Picture Association of America, which said that films are being shown by state prison authorities widely. And when that was pointed out to multiple states, 2 of those states came back and said, we're going to stand on our 11th Amendment sovereign immunity. One of those is North Carolina, one of those states. That's one of the episodes that was reported. And just 2 other points about this. The report from Ralph Oman came in 1988. That was 3 years after the Court's decision in Atascadero. So the register was clear, the former register was clear, and the Congress was clear that this was an emerging problem, and what they had in the way of examples was within a 3-year band of time.
Do you think that record is stronger than the record in the city of Bernie?
Your Honor, I think the intrusion here is much lighter than the city of Bernie. Here, all that states are being held to substantively is the same rule they've been under since the founding. Don't infringe copyrights. Everyone agrees that that is an obligation.
Well, that may be true, but the question is there greater congruence and proportionality here than there was in the city of Bernie? Or maybe that we should re-examine city of Bernie, too. I'm
not urging that.
Okay.
I'm not urging that, and I don't think the court needs to re-examine that because there isn't the same sort of congruence and proportionality problem. Part of what was at issue, I think, in the city of Bernie, and rightfully concerned the court, is Congress was redefining the substantive law. It was intruding upon the substantive conduct of states and basically changing the substantive rules of what would constitute a constitutional violation. That's not what you have here, respectfully, Justice Alito. This is Congress looking at something that is a cardinal sin. It is states infringing federal copyrights, protected federal property. And it's enacting a remedy that is precisely tailored to that. States have to pay what any private infringer would pay. States have to pay what they would insist an infringer of their protected copyrights pay. That's all Congress was doing in the CRCA, and I don't think that there should be the same sort of empirical skepticism on the Court's part, especially given the fact that Congress was so clear about why the problem was newly emerging and why, to use the words that are found in the legislative record, this was just the tip of the iceberg. Because copyright holders, small businesses, individual authors did not have the means, did not have the incentives to be going to court and reporting instances of deprivation.
You said it was inevitably intentional, copying. But North Carolina says that it used the copyrighted works only for educational purposes, and it got that right from the settlement that the parties reached. So that sounds like North Carolina is saying we were far from intentionally copying. We thought we were just carrying out the rights we had under the settlement agreement.
Your Honor, that's what they say. Of course, we're here on a complaint. We're here on a motion to dismiss that was granted, and we are entitled to have all inferences drawn in favor of the allegations of the complaint. And if Your Honor looks at the settlement agreement, it's very clear that there needed to be watermarks and timestamps that were on any images that North Carolina might use. That was not on the images that they were using. When copyright infringement was pointed out to them and they were caught red-handed with that, they returned to infringement. The infringement kept up even after the filing of the lawsuit. That's in the complaint, too. Blackbeard's Law was then passed by North Carolina to make sure that they could get out from under the settlement agreement and they could basically get off the hook for liability for their infringement. That, too, is in the complaint. That's a defense that North Carolina raised in a parallel state court suit. They pointed to Blackbeard's Law to basically evade any liability for their copyright infringement. And so if you look at the complaint, I'd point the Court to paragraph 73 through 75 and to paragraph 80. It is explicit that these were intentional, uncompensated infringements by the state and that they were unconstitutional and violating both the 14th Amendment and the Takings Clause.
Mr. Schaefer, please.
I'm sorry, Justice Kagan. I was just going to say, under the rationale that the Court articulated in U.S. v. Georgia, Tennessee v. Lane, at the very least, it should be open to my clients to be able to proceed on this complaint and show that there was something unconstitutional here, Justice Alito, and the CRCA is valid as to that.
How do we figure out how much is enough in a legislative record? You said these 16 instances are enough. In Florida prepaid, I believe there were 8 instances, and we said that wasn't enough. Now, what's the difference between the two? Other than 8, you know.
Part of it is the fundamental difference between patents and copyrights. In Florida prepaid, the Court's dealing with a body of law where states can be totally innocent in their infringement. They could independently arrive at an invention. They could have no awareness that anyone else came first. You're still going to be liable for patent infringement. Copyright law, by definition, is much more certain.
Yeah, patent law, my field, is a much more strict liability thing, and there's no fair use analysis, which makes it special versus copyright. So we've many times have discussed on Leonard's channel and my channel, we've discussed fair use as it relates to copyright, right? 17 U.S.C. 107, 4-factor test, all that great stuff. Well, in patent law, it's really easy when it comes to fair use. We have a 0-factor test called it isn't fair use. That makes it really simple. And it's like, just because, and in copyright, if 2 people independently invent the same thing and they can prove it, right? Because Leonard has discussed this many times. If 2 people come up with the same work and they, one didn't have access to the other, right? They didn't have access. They both have the copyright in their respective works, even though it's the same thing. So 2 people could write the same book, 2 people can write the same movie, 2 people can write the same song. If they didn't have access to each other, if they didn't in fact take from each other, then neither one is infringing. Both have the copyright, to themselves. Patent law isn't like that. You came up with it independently, we don't care. You came up with it without knowledge, we don't care. You came out with it without access, we don't care. So patent law makes all these questions so much simpler. No, you can't have independent creation. No, and we don't care about the fact you don't know. We don't care about your due diligence. We don't care about your fair use arguments. So none of that works in patent law. So that makes life a lot more interesting for me. So yes. Evil Tribble says, I don't believe you. Something in law can't be that simple. Yeah, I know, Evil Tribble, right? I know. It is a rare exception, rare exception to the rule where things are like very simple. It's like, what is the fair use analysis in copyright law? Well, there's this 4-factor test. Even that is enough because the statute says, what is the fair use analysis in trademark law? Well, it depends on like nominative fair use and blah, blah, blah. What is the fair use analysis in patent? No. What if two people have the same trademark? Well, we get into issues of regional representation and like one person had it regionally, another person had it nationally. So we get Burger King versus Burger King, and they both get issued. They both get their trademark. And by the way, that's a real case. Burger King versus Burger King. And yes, both companies exist and both have their trademark because one got to the other first. And so yes, they both have independent creation. They both have independent stuff. And yes, we have fair use. And in copyright, yeah, we have independent creation. Two different people came up with the same thing at the same time in the fair use. And so that's okay. And patent use, independent creation? No, we don't care. You're liable.
Prescribed. For there to be infringement, it requires that a state have copied the original expression of someone else. Absent that, we're not talking about a copyright.
Because you could look at 16 as a really low number. There are 50 states, and if 16 of them infringed once, that gets you to 16. That wouldn't strike me as a major national problem.
There were 16 reports, oftentimes of multiple instances of infringement or bad faith conduct by states. That's encompassed within the 16 that we're referring to. And as to that, there were dozens of comments that were received about, is this a bigger problem? Is this an increasing problem? And Congress, per the register, found that, yes, it was. And it might be different, Justice Kagan, if there were 16 examples after 3 decades had passed. But the reality is Congress saw the tip of the iceberg of this problem. It saw something that was growing quickly and said, this is a serious problem for the 14th Amendment. We're going to put remedies in place in order to stop it, in order to deter it. And you have from the amici on our side a whole chorus of industry associations, including the Chamber of Commerce, including the Copyright Alliance, the way that this iceberg has grown much, much bigger.
How do we think about that? Because a lot of that is not in the record. Do we close our eyes to that? Do we act like a trial court with respect to those sorts of facts? What do we do?
You have a clear rationale from Congress in the record, which is that there was a newly emerging problem and a tip of the iceberg, and Congress wanted to ward it off, Justice Kagan, and perhaps in a case like City of Bernie, the court might be skeptical as to whether this was a good faith, sound prediction by Congress or whether it was paranoia or whether it was pretextual. I think the court should be heartened here, Justice Kagan, by the fact that exactly what Congress feared would come to pass has come to pass over and over and over again. And there's a one-sided chorus on this. It just confirms the reality, I think, and the soundness of Congress's prediction.
Why hasn't there, after Florida prepaid, why do you think, why has there have not been many instances in which states decide, well, look at all this tech stuff, it's fabulous, we'll just copy all the patents? Why not?
There has been a lot. I mean, there has been a lot of that, and you have that from the amici, and I think it's also influenced licensing.
Well, all over California. Why doesn't California have a budget problem? We'll just take all the Silicon Valley material and we'll copy it.
If you read from Dow Jones, I'd commend
They're doing it?
Your Honor, that's what they did tens of thousands of times over.
I'm not talking about copyright. I'm talking about patents.
As to patents, I don't think that states are in the patent business to the same extent, Justice Breyer.
Why don't they? Here's the solution to all their budget problems.
Well, maybe they're afraid that this court might be there at the end of the day to answer unresolved questions after Florida prepaid.
What question? We apparently said they could go do it.
Well, we think that there's still an Article 1. A question is to the Article 1 basis. That's what we're respectfully urging, and certainly Congress.
I, of course, dissented.
I know it well, Justice Breyer.
Well, what you say raises an interesting question under Section 5 of the 14th Amendment. When we have decided that the congressional record at the time of an enactment that attempts to rely on Congress's Section 5 power is insufficient, and in subsequent years there are events that would have made the record a lot stronger. What does that do to the decision? Does that mean that it's subject to reexamination based on what has happened after that point? So why should we look at events that occurred after the enactment of this?
Because you've never looked at this legislative record.
Well, appealing to the legislative record is always dangerous with a conservative court. You know, it's like you want it in the text or not. And it best shows motives. It can't provide authority for stuff. So I don't know that the legislative record is going to be very helpful. So yeah, so good times.
Before. When you look at this legislative record, you find a predictive judgment by Congress that is a well-reasoned and logical and evidence-based predictive judgment that this is a real phenomenon. It is emerging. It's being reported from multiple sources. It is quite concerning when you look at this from 14th Amendment principles, among others. And so they decided to do what they did. So that rationale is corroborated, Justice Alito. There's a reality to it, a grounding that is evident in what has happened subsequent to that. And I think if the court were to go, from our perspective, the wrong way in this case, the problem will get that much worse, because that will be taken as a green light for states to continue with their infringement without paying for it.
So can Congress say, we're enacting this under Section 5, and we recognize that there's not much of a record of state violations at this point, but we predict that there is going to be?
If the remedy is sufficiently well-tailored around the constitutional deprivation, my answer to that is yes, Justice Alito. I think we are stronger than that. But to take Tennessee v. Lane and U.S. v. Georgia, there the court was looking at essentially what are the facts of specific cases or a specific set of cases and saying from the court's perspective.
So just in case it isn't obvious, because I don't want to make any assumptions, the 14th Amendment issue that they're talking about, right? So the 14th Amendment says that Congress shall make sure the states protect life, liberty, and property, right? And the fifth section of the 14th Amendment says Congress has the power to enforce this provision, this article, by appropriate legislation. So they're saying, well, you know, Article 1 doesn't give them the power to do it, but Article 14, Section 5, which comes after 11, right? Article 14, Section 5 says, well, Congress has the power to pass laws to further the 14th Amendment, which, among other things, says states can't infringe life, liberty, or property without due process of law. So he's saying, well, you can make this a 14th Amendment. You can root it in the 14th Amendment argument. And so it was like, there's a way for Congress to do it that way, maybe. Okay, fair mind.
Yes, this would violate the Constitution. Therefore, the remedy is constitutional as to.
I didn't understand you to be making an argument under U.S. versus Georgia. Am I wrong?
Evil Tribble says, never remind the conservatives that allowing a state to seize copyright works is literally legalizing socialism. Well, yeah, this may be a problem just of Congress's own creation too. So, like, if this goes the other way, the problem is Congress. Basically, when they preempted the field, they created a problem. Because for 200 years, as they were pointing out, you had causes of action in state court. And so, like, this whole 11th Amendment issue wasn't a problem. And then Congress got the idea of, like, oh, we're going to preempt the field, and we're going to make it exclusively federal. So, like, you can't go into a state court and raise a patent claim. You can't do it. You have to go to federal court. So, like, this may be Congress kind of hoisted itself on its own petard. Because it's like, well, you've made it an exclusively federal cause of action by legislation, and the 11th Amendment says you can't bring states into federal courts, so you screwed that up, Congress. So you could go back and give states causes of action, or allow them to have causes of action to solve this problem. So it's like Congress kind of put themselves into a bind on that one. So it was an unintended result. Socialism would be more like we're trying to do it. This would be more like we screwed ourselves into it. So, and just because it would be like bad doesn't necessarily mean the courts can do anything about it, because the law is the law, right? So the 11th Amendment is a real problem here. So it's like, well, this is not good, but the 11th Amendment says we can't do this, and well, if we can't do it, then well, it's not good and we can't do anything about it. So yeah, it's like consequentialism, which you seem to be alluding to at least. Consequentialism is not one of the major thoughts of conservative legal thinking. So, yeah.
Are you making an as-applied argument to this particular case?
I think it's on North Carolina to make an as-applied challenge, Justice Alito. Our respectful submission is that the CRCA is constitutional as enacted by Congress and as relied upon by us in this case. And if North Carolina wants to argue that it is an unconstitutional application as to them, it's their burden to do so. And we support the arguments of our amici that say the court could ultimately decide this case under U.S. v. Georgia or a Tennessee v. Lane rationale. I'm urging the court, in the first instance, simply to uphold the CRCA the way that Congress enacted the CRCA and envisioned for it to be applied.
You didn't make below at least I didn't see an argument based on U.S. v. Georgia.
We didn't, I think, cite U.S. v. Georgia. I think that is true, Justice Ginsburg. We do rely upon the arguments of our amici, and I stand by my submission to Your Honors that if anyone is trying to argue that the CRCA is unconstitutionally applied in this case, it's North Carolina. And the court can decide, as it decides so often when it comes to facial challenges, that the CRCA is not facially unconstitutional, but it could be open to states in an appropriate case to make the as-applied challenge.
You've done a very nice job of showing in your papers the Blackbeard law does trouble me deeply. But you're doing nothing with proving the proportionality to the problem, because there are states that presumably have fine remedies to handle any infringement. You've shown some failings in this state's processes, but I don't know how any of the evidence developed by Congress shows that all 50 states and territories additionally don't have adequate state systems to address this issue.
If I may answer the question, Mr.
Briefly.
Chief Justice. Very briefly, Justice Sotomayor. Number one, in the legislative record, the House report, at committee report at 9 and 10, the House emphasized how important copyright damages are, specifically statutory damages and attorney's fees. It's the difference between loss of the right and protection of the right. That's how important it is. And, of course, the copyright statute preempts any equivalent state laws. So there is no recourse for the copyright holder who's complaining specifically of copyright deprivation outside of the CRCA.
Thank you, counsel.
Yeah, so he's right as to that. Like, so the whole problem is the preemption, and so there is no remedy outside the statute, and maybe you don't have a remedy there either. So I thought it was a very, very good presentation. You know, it's a very technical argument. This is probably one of the more technical arguments we've covered so far on Supreme Court React Time. So it's very entertaining to me, and I hope it's entertaining to you as a result, because it's a very sort of technical argument about the implications of Article 1, Section 8, Clause 8, the Intellectual Property Clause, 11th Amendment, 14th Amendment, Section 5, preemption authority, state sovereign immunity, all kinds of fun, interesting stuff. So it's a very, very technical argument. And, you know, he has some really good lines of argument. He has lines of how you would distinguish the statute on its text, or apologize, not the statute, how you would distinguish Article 1, Section 8, Clause 8 from other provisions in the Constitution on its text, because it's unique in its structure, giving a property right, and so there must be remedies, and therefore there's remedies in courts, and so forth and so on. So he's making a lot of very careful legal appeals, legal arguments that are very nuanced and very technical, and he's also making a pragmatic argument, which is, well, you know, this is a property right, and we need to have some kind of remedy, and there's no remedy if the CRCA doesn't apply. And the problem isn't like Congress screwed up the writing of the CRCA. The problem is, like, they screwed up when they consolidated all copyright law. And so, like, they can't go back and fix the CRCA. They'd have to go back and, like, unpreempt the field, which I guess they could do, but yeah. So it's like, yeah, this is a bit of a technical problem. So yeah, and there is language in the Seminole Tribe case, and one of the things he was saying is, well, maybe that language is dicta, which I guess it is, because, you know, it's deciding more than you have to decide. You know, it's saying all Article 1 powers are insufficient, and that's, like, not the issue. So yeah, it is dicta, and they're saying it's erroneous dicta, so we can ignore it / overrule it / whatever. And the patent case that came up wasn't really dealing with it, and to the extent it is, we could overrule that too. He's making a very good argument. The facts are in his favor. And we are in a motion to dismiss, so ultimate liability isn't even the issue. This got kicked out on a motion to dismiss, 12b-6, for failure to state a claim. So we don't even know, like, factually whether, like, North Carolina did these things or so forth and so on, because it hasn't been proven, right? So there's all that. So that was really, really interesting. I found it very fascinating, found it very engaging. It's a very complicated, very technical argument, but, you know, I think it's great stuff. So that was Derek Schaefer for the petitioners, and now we'll hear from Ryan Park for the state of North Carolina. So let's see what the state of North Carolina has for us, see if they can also weave a very technical, complicated argument and get past the pragmatic objection. So let's see what they got.
Mr. Park?
Thank you, Mr. Chief Justice, and may it please the Court. State sovereign immunity is a fundamental feature of our Constitution's structure. As this Court has repeatedly reaffirmed, immunity from private lawsuits seeking money damages was inherent in the nature of sovereignty at the founding and remains today. The Constitution preserves this aspect of state sovereignty unless there's compelling evidence that the states surrendered it when they ratified a particular constitutional provision. Now, my friend has failed to identify any historical evidence that anyone at the founding remotely contemplated that the Intellectual Property Clause would allow for damages lawsuits against states. In fact, it was not until the 1970s, nearly 2 centuries after the first Copyright Act, that a federal court ever awarded damages of this kind. Now, Mr. Allen seeks to portray this settled state of affairs as somehow anomalous, but nothing could be further from the case. All of Congress's general lawmaking powers are subject to limits found elsewhere in the Constitution, including limits that protect state sovereignty. And so Congress could not commandeer state legislatures and force them to pass copyright protective laws, nor could they, under separation of powers principles, vest judicial review of copyright claims in the Senate Judiciary Committee. Likewise, state sovereign immunity limits Congress's authority to expose state treasuries to the Copyright Act's exorbitant financial remedies. And for that reason, too, the Act cannot be justified under Section 5 of the 14th Amendment. Copyright
I'm not sure I 100% buy the idea that the amount of the damages being high precludes Congress's ability to pass a statute under Article 14, Section 5 power. If they have the power to do it, I don't know that, like, because it's a lot somehow makes it not power. I do like his argument better that, like, courts didn't used to give monetary damages in this situation. So it's somewhat of a historical aberration. That's better. And so, like, all that was being contemplated was injunctive relief. So all you could get would be injunctive relief. Okay.
Rarely rises to a constitutional violation at all, let alone pose the kind of serious constitutional threat that allows for expansive remedies like abrogation. And liability under the Act is expansive. It's vastly greater than anything required by the Due Process Clause. It includes statutory damages of up to $150,000 per infringement, even if the plaintiff cannot prove she suffered any actual harm. And it creates a strict liability regime that covers negligent and even innocent infringement, even though, of course, only deliberate property deprivations can violate the Constitution. And these concerns are far from theoretical. The First Circuit has affirmed a $675,000 judgment against a college student for sharing online a few copyrighted songs, sending him into bankruptcy. And the due process concern that is ordinarily raised in a copyright damages lawsuit is whether they're constitutionally excessive.
What is to prevent, if I can go to the same question, a wonderful money-raising thing? What the state decides to do with its own website, charging $5 or something, is to run Rocky, Mrs. Marvel, whatever, Spider-Man, and perhaps Groundhog Day. All right? Now,
I love it. California opens its own Netflix. I love it. California opens its own Netflix. Pay us $10 to see any movie you want. All the movies. We have them all. They're ours now. Wahahaha. No one can stop us. Wahahaha. That does have some appeal to it on the one level. That's just like, yeah, that'd be an interesting turn of events for sure. Good times.
great idea. Several $billion flows into the Treasury. Okay? Now, if you win, why won't that happen? And by the way, If you're writing to the Constitutional Convention, you're a member, okay? And you write these words. Copyright is to promote the progress of science and useful arts by securing for limited times to authors the exclusive right to their respective writings. But of course, California decides that the person who wrote Rocky, Marvel, etc., will unfortunately receive nothing because everyone will have seen it on the state's own streaming device. What is your response to that?
So there are two important separate issues at issue there, and I'll start with the text. So the exclusive right sovereign immunity does not invade the exclusive right. So I think that that hypothetical misunderstands respectfully the role of sovereign immunity in our constitutional system. As this court said in Alden, states are not relieved of their binding obligation to comply with federal law. And the ordinary remedy required under the Constitution when a sovereign violates federal rights is an injunction and not money damages.
Oh, it's, by the way, we ran it yesterday. You can have your injunction. You see my point?
Yes, exactly. So I agree that under sovereign immunity, as a necessary consequence, there will be hard cases where, statutory violations are not remedied. But that, I think the important understanding that the founders had is that when you sue a sovereign, on the opposite side of the judgment are the people and the people's money. And so the entire point of sovereign immunity, as this court said in Lewis just a few terms ago, is to protect state governments and allow them to make their own choices as to how to spend scarce resources.
They're not going to be hard cases. They're going to be easy cases.
Well,
and it's not. And Justice Breyer's point is that it could be rampant. States ripping off copyright holders. And how can that be squared with the exclusive right if states can do this, which presumably a ruling in your favor will do nothing but encourage them to do?
So I think that's the beauty of the Copyright Remedy Act in combined with this court's Georgia decision. So on extreme hypotheticals, such as Justice Breyer outlined.
Why is it extreme? That's right. You've said hard cases and now extreme. Why won't it just be a standard case and not so extreme?
Well, so whenever a plaintiff can reasonably allege that there has been intentional copyright infringement and there are not adequate remedies, then under this court's Georgia decision, they can bring a direct constitutional claim. We don't dispute that. And so I think to the extent that the Georgia issue is relevant here at all, it's to the fact that it relieves many of these concerns that Justice Breyer and Justice Kavanaugh have outlined. I think that so if we were to discuss the Georgia issue here, I think we have been here litigating this case against Mr. Allen for 4 years, and the first time that he ever raised this Georgia issue of a direct constitutional challenge was in his reply brief in this court. You won't see it in the petition. You won't see it in his briefs below or in the transcripts of the argument. And, of course, for that reason, the lower courts never addressed it. They never —
Your view is that in fact, under the 14th Amendment, this statute is valid insofar as my Captain Marvel example deliberately takes property from people. So is that what your point is?
Yes.
All right. If that's your point, then you concede their point, whether they raised it or not, somebody else would, you concede that this legislation is valid. You're just saying it only applies to instances where the state deliberately takes Captain Marvel. That would cure my problem to a considerable degree. But that is the concession on your part?
I think it follows naturally from this court's Georgia decision. But I would add one additional element, which is to complete a due process violation for a deprivation of property, 2 additional features are required. You need to be deliberate, and there needs to be no alternative remedy. And here there are other alternative remedies that could be available.
Let's see.
So it seems like he's backing away from his position because he realizes he's not getting anywhere. And good for him if that's what's happening. Good for him if that's what's happening. Like it's like the equivalent of the team going to Super Bowl and then like having to rejigger their game because it's not working anymore. Like in, the halftime. It's like everything that got us here is no longer working and having to figure it out on the fly. And so he was saying, well, the classic answer is just injunction. And Breyer said, well, Netflix Calflix, I guess we'll call it. Calflix is operating, and it's like, yeah, you get injunction. Well, they already filmed it, so no remedy. And it was like, and Kavanaugh was saying the same thing. And seeing Kavanaugh and Breyer seeming to agree is nice, in the spirit of what we'll call by philosophy cooperation. It's nice there. And so he seems to be backing off from that position. He's now apparently taking the position that, yeah, it's only if it's purposeful infringement. So it wouldn't be negligent like it might be for normal people, because the state interest is different. But if it's intentional, if they're doing it intentionally and you can prove that, then you might have a remedy. So he's trying to back away a little. Probably a good idea. Let's listen on.
Deliberate first. So it is alleged that North Carolina is infringing on copyrighted works. There's a settlement. And then North Carolina starts up doing exactly the same thing that it did before the first. That sounds pretty intentional to me.
I think it would be intentional if the state had not explicitly bargained for a provision that says we can use Mr. Allen's images for non-commercial purposes. And now I think that highlights how this dispute is really a dispute over the scope of a contractual license that the state received. There is a pending breach of contract lawsuit in state court where the state and Mr. Allen's business partner, Intersol, are debating these exact facts, whether we've exceeded the scope of our license by, for example, not putting watermarks on the images and that sort of thing. So I think that relieves —
I'm sorry. Finish.
Oh, well, I just was going to point out as well that I think that relieves any actual due process violation that could be here because, of course, there's the alternative remedy is a breach of contract lawsuit, which we have not asserted sovereign immunity for. We've affirmatively waived our immunity in state court for breach of contract claims.
What do I do with the Blackbeard law? It is deeply troubling. It's a state saying, even if I'm infringing, you can't get anything. That's basically how I read that law. What remedies do they have under federal law for a state doing something like that?
So I agree it's a strange law. I think there are two separate points I'd like to make. So first, it can't possibly have any relevance to this lawsuit because it was passed in 2015, 2 years after the alleged infringements in question.
Well,
and
it could
it was
to a Georgia argument, obviously.
Well, so I think that exposes the second issue, which is that there are two types of claims in this complaint. There's a copyright infringement claim and related claims, and there's a declaratory judgment claim asking that law be declared preempted. Now, Mr. Allen has not sought cert on the declaratory judgment claim, and that would be the remedy in that circumstance. But the Fourth Circuit, and this is on pages 37 to 39 of the petition appendix, the Fourth Circuit rejected the declaratory judgment claim because it held that the 2013 settlement agreement said that your images, Mr. Allen, are subject to the public records law. And the 2013 version of the law said that photographs that the state receives in public business are public records. And so that amendment couldn't possibly have affected Mr. Allen's rights to his images.
So why wasn't it a taking? Why wasn't the passage of that law a taking when the law declares that something that is private property is now a public record?
So I think it possibly could be on different facts if Mr. Allen hadn't already agreed in a contract that his images were public records. But I think that this would be a pretty extraordinary vehicle for this court to decide when copyright infringement can constitute a taking. I'm not aware of any federal court that has ever reached that question because it hasn't been litigated. So he never alleged that the use of the images was a taking below, and he mentions it in his brief here, but he doesn't even describe the substantive standards that would apply under either a direct physical invasion analysis or a Penn Central deprivation of all economic value analysis. And so I think that the images here could not possibly be a taking because the question here is whether our display of a handful of images and a few educational videos and a museum nonprofit newsletter constituted a complete deprivation of economic value. It surely wasn't a physical occupation of those images. And so I don't think the takings clause is relevant here.
Well, what about Section 5, Mr. Park? Congress clearly wanted to abrogate the state's sovereign immunity. So what would it have had to have done, in your view, in order to do that successfully?
I think that it should have followed the rules laid out by this court in City of Bernie and subsequent cases. And I think that To be, in all fairness to Congress, those decisions postdated this statute here, and so they weren't even trying to meet those standards. And it is an unfortunate consequence, but
well, what would a record that does meet those standards, what would it look like?
So it would be trained on identifying copyright infringement that also violated the Constitution. So it would be intentional infringement, and it would be infringement where there's no alternative remedy.
Well, can't Congress say something like, in copyright, any violation requires actual copying, so we're going to assume that 80% of the violations in the world are intentional?
So I think that would activate the danger that this Court designed the City of Bernie test to prevent, which is changing the substance of law under Section 5. Now, under copyright law, that willful infringement is a recognized standard.
Well, because there's clearly some allowance for Congress to devise prophylactic rules, and this would seem to be a perfect example of, like, you know what, given the requirements of a copyright violation, we think the vast majority of them are going to be intentional and therefore are going to be constitutional violations. Are you saying Congress can't say that and just target copyright violations generally?
I think that they could, I think on a different record, if they had focused on intentional infringement and said, this is widespread, there are no adequate alternative remedies, this is a serious national constitutional problem, and we will enact prophylactic remedies to address it.
Well, how do they show that?
Well, I think at the very least, they focus on...
There was a comment in chat from My Candor says, I thought from reading elsewhere the images were well beyond educational by being used in, for example, tourism. I wonder if that's just wrong or if North Carolina claims they're educational. I don't know anything about the underlying facts of how they were used or in what circumstances or whatever. Of course, those are all questions of fact, and we don't know because there was never a trial because it got kicked out on a motion to dismiss because of constitutional issues. So I don't know if it ever came to trial, like if that happened and what North Carolina's claim would be, because I don't believe up to this point they've clarified that, because why would they? If you can win on the motion to dismiss, why make an argument you don't need to? So, I don't know if they did that. I don't know if they're claiming it's educational. I don't know. We're well past that issue because we're trying to figure out if there's a cause of action and all. All right, so, yeah.
Intentional infringement. I would direct the Court to Mr.
I think I just talked about that. Right. They've decided that 80% of copyright violations are intentional because copyright violations always involve actual copying. It's hard to actually copy something negligently.
Yeah.
Not impossible, but hard. So Congress has decided, the vast majority of these are intentional, therefore are constitutional violations. Now what does Congress have to do?
So I think there would be the additional analysis, which is the proportionality prong of the test, which requires that there be some tailoring of the remedies that are given by Congress to what is required by the Due Process Clause. And no one has ever claimed, I'm not aware of any copyright holder that has ever claimed that the exorbitant remedies found in the Copyright Act are required by due process. I mean, we're talking about $150,000 per infringement, even for an infringement where the plaintiff says, I cannot prove any actual damages. But because this infringement was so egregious on its merits, I deserve statutory damages.
Here is now.
It seems to me a slightly strange position to argue that $150,000 are, completely outrageous for non-infringing conduct, but also sub-argument, but only for the state. It's completely outrageous. The state could be doing this, non-intentionally, negligently, whatever, and $150,000 per violation just for statutory damages, even if they can't prove any actual harm, so forth and so on. I mean, if that's a due process issue for the state, then, presumably it's a due process issue for everybody, right? It seems like it's a very hard argument to make that $150,000 is a due process violation because it's so out of whack with reality. It's a due process problem, but only for the state. It's like the state's in a better position to pay it than your average person, and, including the people they've bankrupted. So I'm not sure how you make the argument that $150,000 per violation is a due process problem when the state is involved, but not for everyone else. That strikes me as a very strange position that he's arguing for. It's a very illogical position. No one's called him out on it, incidentally, in the court, which is slightly surprising. No one's called them out on this, like, incongruity. Maybe because it's so stupid they can't be bothered. But, I could pause the audio and be like, this seems like... I'm not quite sure how you argue that with a straight face. So, yeah.
I see the problem which you've clarified very much for me. It's that the choice for us now is, say, your view would be that the states can copy without doing anything unless that copying violates the Due Process Clause. And in that respect, you agree that the statute can be upheld. Now, if we accept your view, we've got to decide how copyright, copying, and the Due Process Clause fit together, which, to my knowledge, this Court hasn't really gone into. And it sounds like a pretty good mare's nest. Now, the other view would be you'd lose, which you don't want to do. But the other view would be it's likely that there are enough cases where it would violate the Due Process Clause for us to accept the statute as a whole, thereby creating, in a sense, another somewhat different exception to the statement in Florida prepaid. I'm trying to get our issue, and I'm trying to say it fairly from your point of view and from the other point of view.
So let me clarify in terms of your first construct. I don't think that's actually accurate. So under copyright law, a whole range of copying doesn't violate the Copyright Act at all. When there's fair use that applies, when, as here, it's contractually authorized. And so an additional element is required for that to be considered intentional. And copyright law has a built-in set of standards here. What Nimmer says and what the Second Circuit says, what is fairly well accepted in the lower courts, is that willful infringement is when the defendant has actual knowledge that their act constitutes copyright infringement. Now, there is some dispute as to whether recklessness, as to whether it constitutes copyright infringement is enough, but I'm not aware of any court that has ever said that the intentionality requirement, as is sometimes relevant in copyright law, is ever met by mere copying. In fact, 504C2 of the Copyright Act says, quote, innocent infringement is still liable. And innocent is defined as when the defendant had no reason to be aware that the infringement was.
Do you think Congress is able to make judgments about what proportion of copyright violations are indeed intentional? If Congress had said, given the requirement of actual copying, we think a vast majority of copyright infringements are intentional, would that be precluded? Would that fall within Congress's power or not?
Yes, I think that Congress warrants a great deal of deference in this area. And so if they had conducted that examination and they had made that conclusion in a finding, or it was clear in the legislative record that that was what Congress was focused on.
So do you think that's what Congress has to do here? Congress has to say, we think most copyright violations are indeed intentional and therefore violate due process. And here, there are 30 examples. Would that be enough?
I don't believe that there is a strict numerical threshold that is required to legislate under Section 5. I think that what City of Bernie says is that the remedy has to be tailored to the scope of the constitutional violation, right? So if there were 30 violations, then Congress could say, well, here's a proportional remedy to that level of.
Well, why isn't the proportional remedy the same remedy that everybody else has to pay?
Because
once Congress has decided that we think that there are loads of constitutional violations going on, why doesn't the state have to pay what every other actor would have to pay when it engages in those constitutional violations? Why isn't that almost sort of by definition proportional? That's what people pay.
It would be proportional to the Copyright Act, but Section 5 has to be focused on enforcing the Due Process Clause. And the Due Process Clause only requires, at most, compensatory relief. And so I think that exposes how my friend on the other side is trying to constitutionalize copyright law. What we're talking about is the Due Process Clause and what that requires, and not ordinary infringement.
But it's both you and your friend. Because what you will have the courts doing is case by case when, say, California tries to run, they won't run Captain Marvel, maybe it's some old movie, and they say it's fair use. And we can think of not a million, but thousands of examples. And case by case, when someone tries to stop them, the courts have to decide whether the due process clause, in this instance where the University of California thought it was fair use to make 50,000 copies of Norman Mailer's book or something, you say, case by case, we have to decide the constitutional question. I think that's where you're leaving me. And it's tough. It's tough sort of both ways.
Well, so I don't think that's going to be difficult for the lower courts to wade through that state of the law, because they're merely applying the ordinary rules of copyright. So willful infringement, we think, would constitute intentional infringement, and they merely assess whether alternative remedies are available. And that is something that courts are very well equipped to do, to decide whether an alternative claim would be meritorious. Now, one other alternative remedy that no one disputes here is that they could try to sue the individual officers personally. Now, of course, we wouldn't like that at all, but I think the settled state of the law, at least in the lower courts, is that copyright infringement claims can be sued, can be brought against individual state employees.
But they won't have the same deep pocket that the state has. Let me ask one aspect of this question, Mr. Park. States can hold copyrights. They can be copyright holders, and they can sue anybody in the world for infringement. There's something unseemly about a state saying, yes, we can hold copyrights and we can hold infringers to account to us, but we can infringe to our heart's content and be immune from any compensatory damages.
He's dead.
Could Congress say, condition the copyright privileges that states have by saying, states, we're going to allow you to copyright works, but the price is you have to be fair to the other side so that when you are infringing, you will be liable. Does Congress have Article I authority to do that?
So I don't think that they could do that, because I think that would be an unconstitutional condition. It would be.
All right, so that for me is like he has a real problem now with this case. Real problem. So basically, Elena Kagan, like not that long ago, she teed up like the first half of this unfairness issue, where she's pointing out, well, everyone else has to pay this. Why shouldn't you have to pay it, right? Everyone else has to do this. Any other infringer in the world is held to this standard. It's not like it's a different standard. Same standard. Same damages. That seems like fair. It's like, everyone pays the same. And now Ginsburg is coming at it from the other way. She's saying, well, if you had a copyright, you'd want damages for you, but you're saying that, no one damages for stuff you do. So it's a one-way street. You get money for people infringing on you, but not the other way around. And you said you can't even condition it. It'd be an unconstitutional condition. So like the states get everything and people get nothing. So, individuals can be sued for money. We can't be sued for money because reasons. Our copyright is special. Your copyright isn't special because reasons. So this is the second time where it's like trying to point out that, like, for lack of a better word, hypocrisy. It seems like hypocrisy. I feel like there's a better word at use here, but we'll go with hypocrisy for the moment. It's like, or at least double standards maybe is better. It's like rules for me, not for thee, I think is even better than hypocrisy. But it's like, yeah, it's like we get to hold copyrights and you have to respect our copyrights and we can come after you, but you can't sue us. So like the first time when Elena Kagan said it, I was kind of like, okay, I'm gonna let this guy parry this. I didn't think his answer was very good, but I'm like, all right, he parried it. I'll give him a parry. And now Ginsburg is coming at it from the other angle, and I'm like, and he basically tries the same deflection twice. And it's sort of like a magician trying to show you the same trick twice. Bad idea. So like he showed me the same trick twice, and I'm like, no, that can't possibly be right. It can't possibly be right that you can't be sued, and that everyone else gets these damages, but you don't because they're unfair to you, but not unfair to everyone else because due process ? And then Breyer's like, what are we going to do? Try to figure out the due process implications of each case individually? The answer to that question is no. We don't want to do that. No. We don't. We want a rule. We don't want to have to do this ad hoc, one at a time. Figure out if there's a due process issue and then award damages. Are you insane? That doesn't make sense. And then Ginsburg's like, wait a second. You guys have copyrights. you get to sue, but they don't get to sue you. And he's like, yeah. I'm like, wow, that's a problem. It's a problem for his case, right? It's like, it doesn't really flow. It doesn't really make sense. So yeah, it's a property violations, like, so it's like my forecast. I was feeling pretty shaky up to this point, but I feel like at this point I can forecast reversal, and I feel like it's going to hinge on the specific text of Article 1, Section 8, Clause 8, as further informed by the 14th Amendment, Section 5. So my prediction has now switched to reverse, because this guy has tried the same dodge twice, and it is not working. So, yeah. Let's see if he can do anything to change my mind again in the remaining 15 minutes. But it's not going well for him. He's not particularly doing a bad job. He's being a good lawyer. He's just that, his client wants to have its cake and eat it too. And so, you can't do that. The court's not going to let you get away with that. He's trying his very best to put them in the position where they can have their cake and eat it too. But it's like, the court's like, no, we're not going to do that. The fact that North Carolina has passed a specific law specifically to take, steal, borrow, appropriate, whatever, this guy's property for specifically this issue is also like a bridge too far. It's like being too clever. So let's listen to the rest of this and see if he's got anything to dig himself out of the hole he's in. This will be good.
A hard case that this court would probably decide. But what they could do to bring the parties into parity would be to say that states, you can't hold copyrights at all. The states have never claimed a constitutional entitlement to be able to hold copyrights. The United States government can't hold copyrights. What it has done is, as a matter of statute, and this is an interpretation of the 1909 Copyright Act, where because Congress said, United States, you can't hold copyrights, courts have said, well, that implies that states can hold copyrights. But I think that they would be within their rights to remove that right and remove that anomaly.
Counsel, just to get back to your statement that all you have to do is sue the state officers, you'd certainly reimburse the officer, wouldn't you?
Yes, that's correct.
So is that all they have to do? Just name the officer rather than the state in their infringement action?
Well, I think that so, yes, that most states would reimburse their state officers if it was within the scope of their employment, and that there would be additional hurdles in that kind of case. Qualified immunity would apply, and qualified immunity applied in this case, and that's why the claims were dismissed against the individual officers.
Well, then it's not much of a response to say.
Yeah, he said, well, you could sue the officers, and then they're like, really? He said, but qualified immunity. So, like, you can't sue the officers either. So it's more like having your cake and eat it too. It's like it's too much. It's just too much. Too much.
Well, you can sue the officer. He gets thrown out right away, but you can still sue him. So that's a reason not to hold the state liable?
Well, I think it is in this context, and here's why. Because intentionality under the Due Process Clause is roughly equivalent to the qualified immunity analysis. That's what this court said in Kingsley versus Hendrickson, that its intentionality is judged by an objective standard under all the facts and circumstances available to the officer. Is what they did, can that be construed as intentional? That's very similar to the qualified immunity analysis, and I think it mirrors what the Fourth Circuit did here, where it says, well, there's this contract. It's a little bit ambiguous. It's not clear whether these are non-commercial uses. But we won't say that what they did was intentional when a reasonable officer would read that contract and say, well, I think that educational videos and a museum newsletter are non-commercial uses, and so they're covered by the contract.
Mr. Park, can I take you back to the interesting suggestion that perhaps Congress could have justified what it did in this act by saying that we predict that a high percentage of copyright infringements are intentional and therefore violate due process. If we were to accept that, is there any reason why the same reasoning would not apply in patent litigation?
No, I don't believe there is any distinction there. And I think that highlights how I don't think that that is actually what Congress could do if it didn't match this court's jurisprudence, or at least the jurisprudence of the lower federal courts. If the lower federal courts have not said that most copyright infringement is intentional, it's the rare exception that infringement is held to be willful. And so I think that it would be based on the legislative record. You'd evaluate whether Congress had a good faith basis for making that conclusion. I think on the current state of the law, as I understand it, they would not have that good faith basis. So I'd like to just turn very quickly to this idea that future infringement could be enough, or that these, examples that have arisen after the Copyright Remedy Act could be relevant to this analysis. I think that would be at odds with all of this Court's Section 5 cases, including the cases where this Court has upheld abrogations as valid, such as Hibbs, and all of the...
1 second. Yeah, he's struggling. He's talking for a little bit now without an interruption, which is never a good sign, as I pointed out. It's like 1, 2, 3, 4, 5, 6, 7, 8 paragraphs. And you actually heard him pause right there. You heard the break in him saying. The reason he was pausing is because he was expecting a question. And no question came. That's not a good sign. It's not a good sign when you're talking for a while and they're not interrupting you. And especially like when you're not really like saying anything like important. It's like, it's not a good sign. They're not. They've lost interest in your case. They've lost interest in what you're saying. Not a good sign. He knows he's in trouble.
Those cases, they said Congress must identify a widespread pattern of constitutional violations and in the legislative record before it. And I think that goes to the heart of the City of Bernie test, which is evaluating Congress's work and making sure they're not trying to change constitutional law through Section 5. They have to be enforcing the law as interpreted by this Court. I think if I could make just a few words on stare decisis, because I think that's incredibly important in this case. I think that my friend has acknowledged that a ruling in his favor, at least on Article 1, would effectively overrule Florida prepaid. That there would be some interesting law review articles written about whether it did so on its own merits, or whether there has to be subsequent litigation, or whether it automatically revived the act, but no one that has ever evaluated the intellectual property clause has ever been able to identify any distinction between copyrights and patents that could be relevant to this analysis. And so, yes, if this Court rules on the basis of Article 1, we think that Florida prepaid would be overruled. And I don't think that Katz can bear the weight that Mr. Schaefer tries to place on it. So Katz, and this is at page 363 of Katz, it says, our assumptions about the bankruptcy clause were erroneous. And I think that was a reasonable thing for this Court to say, given that there had been nearly a century of precedent going all the way back to 1933 in New York v. Irving Trust, saying that bankruptcy discharge proceedings...
Well, it said the blanket statement in Seminole Tribe was incorrect, and Florida prepaid relied on that same blanket statement in Seminole Tribe. Seems to be a problem for that blanket statement in Florida prepaid.
Yes, I completely agree. I think that the reasoning of Florida prepaid's Article 1 holding has been undercut, and that would be a reason to revisit.
And it's 2 sentences.
That's correct, Your Honor. It's very limited. And it's based on a principle that has been undermined by Katz, I think. So you would apply the ordinary rules of stare decisis. That's the only point here. Not that it has not been undermined in any respect. And I think if you view this question in terms of the principles that stare decisis is supposed to uphold, legal stability, reliance on this Court's decisions, that would really bring this issue into focus. Because everyone who has evaluated Florida prepaid and whose job it is to evaluate...
I mean, I haven't gotten into the details of Florida prepaid to know. It's just never come up for me in any case I've ever worked on, because I don't deal with state action, So it's never come up. So I don't really know what it held, but if it was relying on a general statement, the general statement is overbroad or whatever, sure, let's overrule Florida prepaid. Why not? We can do it here, although strictly speaking, not necessary. We don't have to. It's not like a requirement, but we could and save ourselves the time from having to do it again later. So we could overrule Florida prepaid and get ourselves a twofer. So why not? Let's overrule Florida prepaid. Say, yeah, we were wrong that time. You have your patent remedy, and by the way, you also have your copyright remedy, and we'll also consider other stuff maybe later too. So, works for me.
With this court's rulings and say, what are my legal rights and obligations, has said that it covers both the Copyright Remedy Act and the Patent Remedy Act, including the United States government, which has...
I really don't follow your reliance argument. Yes, the state may be relying, but who other than the state relies on the state's right to infringe without damage liability? Who other than the state?
I think that I'm speaking about the state's reliance interests, or the states generally.
Justice Blackleaf takes state reliance interests much less seriously than other reliance interests. I don't really care very much about the reliance interests of the state. Not saying they don't exist, but they're much less important than anyone else's reliance interests. We do stuff all the time that affects the state reliance interests. Like when Miranda was decided, kind of affected state reliance interests. Does anyone care? No, not really. So state reliance interests, I just don't care that much about state reliance interests. They're the state. I just don't care. That's part of the problem of being the state. Deal with it.
And I think here's why that matters, and I would bring it back to this case. So our Cultural Resources Department is operating on a shoestring budget, trying to recover and excavate and preserve the remaining aspects of the Queen's Anne Revenge, around 40% of which, under their estimates, is still on the bottom of the ocean. And they are doing that work. And it's when there are competing legislative priorities, such as school funding and disaster relief, and all sorts of other more important priorities, it's hard to get money to fund important work like this for the state's history.
Though, Mr. Park, what Justice Ginsburg was suggesting, that it's not the strongest reliance argument to say we relied on this Court's holding to infringe other people's rights?
Not to infringe on other people's rights. I think that what they did here is that they posted online on good faith reliance on a contract.
Okay, look, the contract issue, I don't have an opinion on. Because I haven't looked at the contract. I haven't looked at the facts. I have no opinion on the underlying liability. I have zero opinion, and I mean that genuinely. Because I don't know what North Carolina exactly did. I haven't been paying that much attention. And, because it's not relevant to the case at hand. It's an issue on a motion to dismiss. Got 12B6. So I have no idea what the facts are. I have no idea what their contract is. I have no idea what it says. I have no idea what North Carolina did. I have no idea if it falls within their contract or not. So maybe everything North Carolina did is totally fine. It's possible everything North Carolina did is totally fine. I mean, they had an agreement. They had a contract, right? They had a settlement agreement. Maybe everything they did, they felt was within it. Maybe that's possible. I don't know. Go to court and treat it like a breach of contract argument. A breach of license. A license is just a contract, right? So it's a contract. Treat it like a contract. Okay, what does the contract say? Interpret it like you do contracts. It's not like rocket science to interpret contracts. And then figure out if it's inside the scope of the contract or not. And if it's not, then you've exceeded the contract. Pay damages. It's not super hard. So yeah, North Carolina, to the extent North Carolina has reliance on the contract, that's great. That's what contracts are for. They can go argue that in state court and say, we didn't breach the contract. If that's true, great. No liability because you didn't break the rules. So, if you are relied on your contract and it says what you think it does and you didn't break the rules, there's no liability because you didn't do anything wrong. You did what you were in alliance to the contract. And Allen has just wrote a bad contract. Could be. Something you can argue about in district court. It's not hard. You do it every day. Lord have mercy.
It could have also been unfair on good faith reliance, on perhaps an aggressive reading of fair use in other situations. But they did that because they thought that they wouldn't have infringement liability of up to $150,000 per work. And there are, I can give legions of examples where juries have awarded astronomical copyright damages. There's a jury in Minnesota that awarded $1.9 million against a single mother of 4 for downloading and sharing a few copyrighted images online. And the Eighth Circuit reduced that judgment to $220,000. She still went bankrupt. But because these issues are ordinarily thought to be a due process problem on the other side, And so I think that you would see states retract from their uses of copyrighted works in a way that benefit the public. There's an amicus brief from the Library Association saying that this would imperil copyright infringement liability, monetary liability, would imperil digitization projects and other works of archives. And I think states are simply different. I don't think it's respectful to the interests of state governments to say
you can finish the sentence
that they will infringe at will if damages liability is taken off the table. Thank you.
Thank you, Mr. Park. 4 minutes, Mr. Schaefer.
Yeah, I don't think he's a bad attorney. I think he's a fine attorney. I don't think I could do any better in this position. It's just like the state wants it all. They want the ability to hold copyrights and not respect other people's copyrights. They want the ability to sue other people for damages and not be sued for damages. They want everything. It's like, it's just too much. It's too much. You're too greedy. It's like you have to play by the same rules as everyone else. Not to mention the fact that you're taking other people's property, which of course is always disturbing. So it's like you just can't do that for the hell of it. You want to prove maybe you have to prove intentionality. Maybe like innocent infringement wouldn't apply to a state. That's at least a viable argument. You could make that argument, presumably, but it's just too much. You're asking for too much. So like this guy's argument doesn't hold together like the first guy's argument. The first guy's argument was a very cohesive, networked case where everything relied on everything else and formed a nice little cohesive structure at the end. This guy was like trying to make an argument and like, I don't know, what's the analogy here that you want to put into? Like one too many things put into the sauce and ruins the sauce? One too many ingredients? It's like, or too many ingredients or three too many ingredients? Like, there was something workable here with less, but yeah, and then as someone pointed out, Evil Tribble pointed out, the Blackbeard law also was not a help. So it's like 1, 2, 3 things too many in this pot for this to work. And like, no. All right, so let's yeah. So let's see what the first guy has to say in his 4 minutes of rebuttal. He's got 4 minutes to rebut, so let's see what he's got.
Mr. Chief Justice, may it please the Court, starting with Blackbeard's Law, Justice Sotomayor, I want to be clear, Blackbeard's Law was passed after the allegations of infringement in this case, after North Carolina had been caught infringing. It was then used, as alleged in the complaint, by North Carolina to defend against the state court suit by Intersal because they said Blackbeard's Law had voided the settlement agreement. It was now contrary to North Carolina's public policy, and they couldn't be held to the settlement agreement, nor could they be held liable. That's in the complaint. That is as alleged, and I don't think there's any ability by the state in this posture to contradict those allegations. As to the Intersal dispute that Mr. Park talks about in North Carolina State Court, Intersal does not hold the copyrights, so their suit by definition it's not trying to vindicate the copyrights. That suit was just decided by the North Carolina Supreme Court after North Carolina for years interposed sovereign immunity defenses saying that the breach of contract action had not been properly filed administratively. There needed to be administrative exhaustion. So that suit is continuing on. It's not as though sovereign immunity was no impediment, and it's certainly not out to vindicate copyrights. As to the images in question, I just have to emphasize, Your Honor, my clients have put in 2 decades of work, essentially, trying to be there to when these images are excavated underwater at great expense, at great risk, and this is all, essentially, my clients get out of it, the copyrighted images. And the allegations of the complaint are that North Carolina not once or twice, but repeatedly and systematically was infringing those copyrights, was caught doing it, paid $15,000 under the terms of the settlement agreement, went back to doing it even after this complaint was filed. They continued to infringe the copyrights. And the resolution by the Fourth Circuit is everything is dismissed. And as to injunctive relief, Justice Breyer, Congress found it provides no meaningful remedy in this context, different from the patent context. But it's all about getting paid for past damages in order for this to be a meaningful remedy. And in this case, the request for injunctive relief was thrown out. Why? Because North Carolina did exactly what you articulated, Justice Breyer. They said, well, we've stopped infringing those images. Now that you've pointed it out in court, we've taken those down. What else have you got? And without benefit of discovery, the Fourth Circuit viewed that as the end of the request for injunctive relief, and that's how it goes in copyright cases. Now, as to the notion that there could be individual suits against individual officers under 1983, you're exactly right, Chief Justice. Qualified immunity is a defense in this context. I'd commend to the Court the Fourth Circuit's decision on this point. It's at 37A, 39A. They basically said because there's some defense that's available to these officials, they say they read the settlement agreement differently. Maybe they didn't know it was copyright infringement. Maybe they weren't looking for the watermarks or the timestamps. That is a good enough defense. Qualified immunity gets them out of the case, and those claims, too, are dismissed. That's why it's so important, part of why it's so important in copyright cases, that there be secure remedies for copyright holders. That's true against states, and it's true against anyone. Most copyright holders, unlike patent holders, Justice Alito, these are small fish. They have not sunk costs into this sort of a registration. And they need to have secure statutory damages and attorney's fees in order to come to court at all. Because in copyright cases, as Congress found from the testimony before it and the submissions of the register, you need to have statutory damages. Otherwise, how can you quantify what the harm was? And especially given how small the stakes are in copyright cases and how underheeled most copyright plaintiffs are, if you don't have those statutory damages, you don't have a right. And that is specifically found by Congress in the House report at pages 9 and 10. So, Justice Kavanaugh, you ask about what happens in ordinary cases. This is exactly what Congress looked at. They said the rule in copyright cases, absent the CRCA, is that copyright infringement pays for states. They will get away with it every time. You will not have copyright holders who have incentives and means and attorneys to bring suit. That should not be the outcome in this case. And to say respectfully that it's incumbent upon every copyright plaintiff who sues a state to prove a constitutional violation and willfulness in the way that Mr. Park articulates is to render the right nugatory, and the CRCA as well. Thank you, Mr.
Thank you, counsel. The case is submitted.
Yeah, okay. So pretty interesting stuff, all things considered. I predict reverse. I predict 9-0 or 8-1 maybe. So I could see Thomas doing some stuff on the 11th Amendment jurisprudence, which honestly I would be very excited to read if he writes it, because I think it would be very informative, like on the 11th Amendment jurisprudence in terms of like its interactions with all these issues. Because like there is an 11th Amendment problem out here. Now there's ways around that, as I've been pointing out. Article 14, 5th section gets you there. The specific language of Article 1, Section 8, Clause 8 can get you there. So there are some ways around this problem. But I could see Justice Thomas doing like an 11th Amendment analysis and saying like the 14th Amendment isn't specific enough to overcome this. It wasn't designed for this, blah, blah, blah. And doing some like really interesting 11th Amendment analysis. So if that happens, I think it will actually be a really, really interesting dissenting opinion, because like, I think it'll just be really interesting and informative in terms of legal rationales. So if he writes a dissent, I think it might be super, super interesting. So you can look out for that if that happens. But so I'm going to say, what the hell? I'll say 8-1 for my formal prediction. I'll say 8-1, Thomas to be in dissent on some 11th Amendment stuff. That'll be pretty interesting. Don't know who's going to write the majority. Don't really care. It can be anybody. It doesn't matter. Take your pick. Probably not Gorsuch if I had to guess. But anyone else will be fine. Kavanaugh maybe, or Alito maybe, Kagan, Breyer. This seems like a Breyer opinion. Let's say Breyer writes the opinion for the majority. This seems like a Breyer opinion. So I'll say 8-1, Breyer to write the majority, Thomas to write a dissent on some 11th Amendment grounds for a prediction. But yeah, that seems pretty interesting stuff. So yeah, and as Ewan Marshall points out, he could do it as a concurring as well, and that would make it 9-0 if he agrees with the result, but agrees for other rationales. So it depends, like, it depends on a whole lot of things. I mean, it could very well be a concurring opinion, and then he would come back in with some 5th Amendment analysis to undercut the 11th Amendment stuff. So, like, yeah, he could say the 14th Amendment doesn't really work, 11th Amendment is applicable, but then the 5th Amendment redress or remedy stuff. So there's some avenues there, too, if it wants to be a concurring. I think 8-1 for my prediction seems probably fine. 8-1 to reverse. I think North Carolina just went too far. They want too many things at the same time, and then passing this law specifically says, we're not going to pay you is like, not really. And there have been other instances from other states. And like, do we really want to get into a position with Calflex? Do we want this to be a thing? No, probably not. So it's like, yeah. And so the issue is breach of contract, right? I think the employees are probably immune under 1983. Because it wasn't well established, right? Because we're just going to establish for the first time ever that states have a liability. So I think the employees are in total clear on a 1983 case. I don't think a lawyer should bring it at all. So I don't think there's a 1983 cause of action. I think your cause of action is against the state for breach of contract, breach of license, with a copyright claim thrown in, because the copyright claim is going to get dismissed. But that's okay. You throw it in anyway so that you preserve it in case, something goes wrong on the back end. So you make both arguments, even though the copyright argument's going to get thrown out. It's okay. It's expected. And then you go forward on the breach of contract and you go prove it or not. And figure out if there's damages, and if so, how much, blah, blah, blah. We know how to do this. It's not that complicated at that point. And then North Carolina can make their, but it was okay under the contract, but it was okay under fair use, but it was okay because, I don't know, whatever. They can make their arguments and, see if a jury buys it or not. That's what juries are for, to determine facts. That's what we like juries for. They determine facts. They will tell us. They will tell us what actually happened. They will tell us in reality what occurred, and then we will know for all of time that is what occurred, and we will all be enlightened. So, very interesting, very good stuff. Very interesting case. Very technical case on the interactions and stuff. Because it was involving a provision in the Constitution that doesn't come up a lot, the 11th Amendment, and dealing with the copyright law and dealing with a precedent that seems to go the other way. That precedent probably now has to be reversed. You can do it here or do it elsewhere, whatever. Maybe you do it here just to save yourself time. If you can, why not? Just reverse it. What the hell? Just reverse it now and save yourself the time, or do it later, whatever. So yeah, you have that problem. You have Seminole Tribe, but you don't have to deal with the broader case. You don't have to deal with the broader implications of Seminole Tribe. You can deal with that another day. You can make a carve out for this, and you can even really stamp down it if you want on the language. You can distinguish Article 1, Section 8, Clause 8 from other language if you really want to stamp down anyone trying to make the argument somewhere else. So there are ways to deal with that in the opinion, to constrain this. I think that'll be very effective. But yeah, I don't see what state was this? Georgia? What state was this? North Carolina. I lost it for a second there. I was like, what state is this? Yeah, North Carolina. I don't think North Carolina is going to win this argument. It's just too much. So I'm going to say 8-1 to reverse. So that's my prediction for this. And we'll see what there were for comments. I did get a couple comments. People wanted me to put cases on my list of potential stories. They are my list of potential stories. So we will potentially do them. So thank you for the stories, as always. So yeah. Evil Tribble said, how many people have to have their rights infringed to make Alito happy? Yeah. I think it was I'm not quite sure I'm still not 100% sure what he was getting at with that. I'm not quite 100% sure what he meant, but whatever. FOIA your state for a copy of Star Wars. Yeah. Can you FOIA it from your state library? I guess you can just go check it out. I'll give you a library card for free. We can't expose the state's treasury to the consequences of actions. Yeah, that's right. Just don't break the law. Just don't break the law. Don't break the law. That'll be great. Evil Triple, yeah. Kay shut him down hard. Yeah, I sure did. That was fun. Let's see. The guy's argument was just too much. So he's trying to do it once. Yeah, with the double treatment, dual standards thing. Rules for me, not for thee. No, not gonna work. Channel Kilo versus New London and take Star Wars from Disney. If wishes made it so, man. If wishes made it so. Yeah. When will the red light go off? Yeah, not seen enough, right? Because that was a little bit painful. Yeah, was it Ewan said the fifth time he mentioned $150,000 like anyone's cares. He kept saying it like it's a shocking number. I mean, if it's shocking for the state, it's shocking for everybody. So it's just yeah. Good lawyer with bad facts, yeah. Would you make the state's argument in front of SCOTUS? I would make any argument that's even borderline possible to make an argument in front of the Supreme Court. Yes, I would argue this on behalf of North Carolina if they called me. I would grin and bear it, and I would make the very best argument Blackleaf could possibly make and get destroyed. But I'd have the experience. Totally worth it. Yes, I would do it. Yeah. I know this case isn't the point, but in general, if you have a contract with the state passes a law that basically circumvents this accounts of breach. Presumably. I mean, you'd have to know more, but yeah, of course. Yeah, your 9-0 fantasy SCOTUS prediction is in. Fair enough, E1. I'm going to go 8-1 on this one. But yeah, good times, guys. I had a lot of fun on the stream. I hope you did too. For the 35 of you who are currently watching, if you would be so kind as to give this a like, the little thumbs up icon, I would appreciate it. I'm always happy to keep producing stories for you. I hope you liked the story I released earlier today on the ICE raid gone wrong on the suppression. That was really good stuff. And, we're growing and things are going really well for the channel. So I'm very, very happy camper. And, we'll be back next Friday with more Supreme Court Reacts. We'll see what happens on cases being decided. I think 2 cases so far have been decided this term. So we're just, trucking along. We'll see what goes on. Until next time, my friends, I hope you are well. Until later, cheers and goodbye.